in the morning. It's the 19th day of November 2025. The board here, as you can see, is Mr. Tillis to my left, Mr. Freeman to my right, and I'm Steve Prater. We'll be handling the revocation hearing for Mr. Henry Clifton, who is an East Baton Rouge parish facility. Is there any staff from East Baton Rouge in the room?
Yes, sir. Lieutenant Murphy.
Lieutenant, thank you for hosting us today. We appreciate that very much.
You're
Mr.
welcome.
Clifton, would you tell us, you are Mr. Clifton, correct?
Yes, sir.
Okay, Mr. Clifton, what's the purpose of the mask?
The mask is for tuberculosis, whatever they got going on here. I'm just trying to keep myself from getting sick.
Okay, okay. Would you is that okay if you take it down for now so we can hear you and see your lips moving?
Yes, sir.
Okay, thank you, sir. Okay, your case, well, let's see, what's your DOC number, sir?
531107.
Okay, and have you signed a waiver form of the hearing, agreeing to this hearing today and understanding that you're gonna have a lawyer that it'd be a privately funded lawyer?
That's that paper in front of you.
Yes, sir.
Okay, did you sign that paper?
Yes, sir.
Okay, all right, Mr. Tillis to my left is gonna be handling the questioning and calling on your supporters to speak. So, Mr. Tillis, would you take it away?
Good. Good morning, Mr. Henry. How are you?
I'm fairly well, sir. Thank you. Good morning.
I'm going to read some violations and you can plead guilty, not guilty, or with a statement. Rule violation 4. The offender failed to refrain from criminal activities due to an arrest for simple battery on 4/10/2025. The subject was served with protective order on 7/29/2025 and was found to be in violation of the order, failing to leave the residence location 5568 Lancaster Avenue. Hearing continued 10/21/2025. Trial same date on 10/21/2025. The pending charges of simple battery was dismissed in city court. How do you plead? Guilty, not deal with the statement.
I don't know how to plead with that. I don't understand because this is my first time being in front of the parole board. Now, I guess maybe I should plead with a statement. I suppose my statement would be that the only defense I have is that my charge was dropped. Yes, sir. And that it did not happen in accordance to how it was stated. I do not wish to waste the board's time, sir. I'm just trying to get a good understanding of how this even works. I'm not sure. I've been doing what I could to stay out of trouble.
Okay, you were arrested for simple battery.
Did I commit the simple battery? No, sir.
Okay, tell us what happened.
Okay. So, my brother I live with, and I was in bed that morning. He was going to work, and his daughter was taking him to work, and I believe this day was her birthday. And so she took him to work and come back to the house and turned the radio on in the living room and had it vibrating the walls. And I don't know if she cared or not, knew or not, or what have you, that there was someone in the house. I believe she knew that I was in the house asleep. And so I made it known that I was in there asleep. I got up and I made my presence known, and I beckoned for the radio to be turned down. She didn't do it. And I went on and went in the living room and unplugged the stereo. She couldn't get up, she couldn't do it because she was dancing on the floor. She didn't even see me when I was beckoning for her to turn it down because she was dancing on the floor. So I walked past her and unplugged stereo. She got up off the floor and proceeded to stop me from unplugging it. And I left it alone and went back to the bedroom. She called the police. I called my brother. And he came. While they were there, they wrote me a summons. She told them that I put my hands on her. He knew that wasn't true. He pulled up from his job, drove there and talked to the police, and the police released me to him. They just wrote me a summons. And I got in the car with him and we left, and he went back to work and I went with him.
Okay, thank you. Thank you very much. We have rule violation number 5 on 7/29/2025, while the agents were waiting for the subject to vacate the property located at 5568 Lancaster Avenue, and the subject's belongings was a machete. How do you plead?
That's not my machete. It was a shop. It was a tool shop. It's my brother's shop. I was inside my brother's shop. I wasn't in the house. I was in his shop working, doing what I was legally, what he told me I could do, what the court said that I could do. We had just went to court and got that understood that day. My witness is right here with us. My brother Orlando is on the meeting, and he has a copy of the order that the judge put in place.
Okay, we'll ask him in a few minutes.
Yes, sir.
Rule number 10, the subject failed to pay in supervisional fee and is currently $994 in the rear. How do you plead?
Plead guilty to that.
Okay, we're gonna let some people speak on your behalf, which is your brother who is on Zoom. Mr. Henry, what can you tell us about your brother?
Good afternoon, Paul Borough Board. Thank you for allowing me to speak on my brother's behalf. Yes, I invited my brother to stay with me upon his release in December of 23. And he was invited to stay. I want to help him and continue to want to help him get back on his feet. I even had him doing some odds and ends jobs with me. With the various things that I do. I set up sound for local bands in my hometown, and that means moving equipment, speakers, mixer, microphone, cables, and that sort of thing. So he comes with me to do those various things. I even have friends who also hire him just as a basic labor hand, helping them out in their endeavors. And he's been with me at my home ever since. The problem, the only issue was with him and my daughter. My daughter was not interested in having him at our home, and I did my best to quell her concerns about my brother. He was really just being there, just trying to do his time, his parole time, and work it down. But my daughter just simply did not want him there, and I tried to be the mediator between the two. Not that my brother was causing any kind of issue, like I said, and this is my daughter I'm talking about. I never want to go against her, but really, honestly, she did not want him there. And we were in the process of trying to find housing just so I could get some separation between the two of them. And, we were really close to that prior to him being picked up. But no, he was allowed to work in my shop. He likes electronics. He works on those, on different things. So I have all kinds of tools in my shop. And the machete happened to be one of the things that was found. Had I known that was not something that was supposed to be even around him, I would have immediately removed it. I had no idea about that kind of thing, but I've got all kinds of tools in my shop, and having access to that was one of them. So I'm sorry that he got that charge for that, but no, there was no purpose for him being charged with that, in my opinion. He's been doing his best to just stay out of jail. I believe it's time not right now, but when he got out in 23, I believe him then. He didn't want to go back. And all I'm trying to do is help him meet his criteria, try to help him find work to pay his bills and become self-sustaining again.
Okay, thank you so much for your comment.
Thank you.
We have Miss Crystal.
Yes, sir.
You go to the podium, please. Tell us what you want us to know.
More so, thanks for having me, but more so of a character witness for Cliff. We met, I guess, shortly after he got out in December. And he's a good guy. He had a lot of opportunity when he was out there. He did work with his brother. That's how I knew him. He worked with his brother. In my sound engineering. He had a lot of opportunity because he worked on several different projects with me, through other friends. I just know they had a lot of issues. The niece had a lot of issues with him being there, her personal issues, But I witnessed several things, her slamming the door and things like that. So I didn't see him do anything to her. So for the most part, I feel like it's kind of just very issues.
Okay, thank you so much for your comment. Anyone else have any questions?
And I'm listening to you, but it looks like you've had problems in the past with that temper a little bit, with that restraining order with your ex-wife and the kids, and then you go down there and I think you took a car, and then probation officer had to order you to bring it back because she had a protective order against you. What's going on with that? I mean, and she said she didn't like the way you disciplined the children. How you discipline?
Well, I didn't physically discipline them, but I definitely made sure that I was stern with my children and let them know that they are beautiful and that they are children that needed to have restraint about themselves, because they were in a situation in that I'm not able to be there. So I needed them to have control of themselves and not put themselves in a position to where they would be in jeopardy.
Gotcha. I have no further questions.
I don't have any questions either. I think it's time.
Mr. Henry, I agree kids should have some discipline, and you didn't physically whip them. My vote today is going to be do not revoke.
My vote's gonna be do not revoke, but I don't want him having no more contact with that niece. And I'm ordering you to stay away from that niece. So if you got to live with that resident, you need to find another one, because this is gonna keep happening.
So as we have my brother on the line right now. That is the only residence that I have at the moment.
I'm not
We
letting
are-
back around that piece.
I'm actually saying that she doesn't live there.
Okay, she's moved out?
Yes, sir.
And your brother also said he's trying to find a residence for you.
Right, well, when she comes to that house, you leave,
Yes, sir.
okay? All right, well, my vote's to do not revoke, but if
Okay,
you
yeah.
see that niece, you are to leave.
Okay, you have 2 votes to do not revoke, and you need 2 votes to carry the day on a hearing like this. My vote would be to revoke you. I think there's too much smoke here. And I think that immediately when you knew there was a protective order for you, you should have left that residence instead of sitting there on your computer waiting on the agents to get there to talk to you. Order of the court doesn't say you gotta not be around this residence until you've talked to your brother. It says don't be around that residence. And
Actually,
so I don't need you to say anything. My vote is to revoke. But I have a single vote. And I got 2 that say do not revoke. So, as of today at 10:14, your parole has not been revoked. That's the end of this hearing.
Thank you for adjusting clerk relief report. Council, today's the date scheduled for the arraignment and the pretrial, and as to the arraignment.
Wait for reading.
The court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, and as to the pretrial.
Your Honor, my client's going to tender a guilty plea to a lesser included charge for operating negligently impaired.
All right, sir, please raise your right hand. You solemnly swear or affirm testimony about to give with this matter be the truth, the whole truth, and nothing but the truth.
That's right.
Okay. And you heard the plea that was placed on the record, correct?
Correct.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
I do.
You also understand by entering into a plea that you'll be waiving some of those rights.
I would understand.
You've gone over the possible penalty as a result of your plea, whether in this court, any other court or administrative agency, correct?
Correct.
And knowing all of that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, they haven't.
Any immigration issues?
No, Your Honor. May I please have the date of the offense?
October 18th. And counsel, if you can please order your client.
Mr. Phillips, were you operating a vehicle in the city of Riverview on October 18, 2025? Yes, I was. Prior to operating that vehicle, did you have any alcohol? Yes, I did. All right.
Oh, I'm sorry. Is you picking him up? Okay.
All right, and how much alcohol did you consume?
A fair amount, enough to blow 0.2.
All right, you believe that alcohol impaired your driving by not being able to stay in your lane?
Yes, it-
Satisfied, Your Honor.
And you stipulate to the .222, counsel?
Yes, Your Honor.
The court will accept the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge and dismiss the original charge per the plea agreement. As to bond counsel,
Your Honor, my client came in timely. He was very respectful. He's 32 years old. He works as assistant manager at Applebee's. He lives in Westland. He doesn't have any children. He graduated high school in 2011. He's not on probation or parole, as I indicated, with no pending cases. I asked probation for a first one.
all right, sir, when's the last time you consumed any alcohol?
not since I got arrested.
I'm sorry?
Not since I was detained.
Okay, and sir, you know at what level you're intoxicated because you have a prior from 2017. And have you ever failed to appear in court for any reason, sir?
I have not.
Are you on probation or parole anywhere?
I am not.
And are you out on bond in any other jurisdiction?
No, I'm not.
The court's going to continue your cash bond. The court's going to also order, sir, you to participate in random testing. Given the levels and given your previous conviction, the court wants to ensure that you're not going to possess or consume any alcohol or drugs that are not prescribed. So you're going to go over to probation, sir. You're going to get a copy of your bond conditions as well as your testing information and a whole slew of other information. Okay? All right, good luck to you. We'll see you back at sentencing. Thank you. You have a good day. We're on the record in the matter of the City of Riverview versus Ethan DeLong, 251312.
Good morning, Your Honor. Victor Shemke, appearing on my client who approaches.
All right, and sir, your name for the record, please.
Ethan John Long.
All right, and so this matter is adjourned because there was not a factual basis on the plea that was put forth previously.
That's correct, Your Honor. And then I was able to get the discovery from Mr. DePloy. I reviewed with my client, had a dialogue with the prosecutor. Based on the evidence that was provided, my client is now prepared to enter a responsible plea to a lesser included civil infraction of careless driving and a guilty plea to the no insurance charge.
Okay, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes.
Well, hold on. Mr. Carmen, your appearance for the record, please. Mr. Carmen. Can you message somebody out there, please, to have Mr. Carmen come in here? Mr. Carmen.
Michael A. Carmen, P73824, on behalf of the prosecution, Your Honor.
Okay, and so on the matter of Mr. DeLong, did you speak with the victim in this matter?
I did, Your Honor. I don't think his account of what happens matches the evidence, which I reviewed, the video and the photographs. That's why I'm offering civil infraction.
Okay, and so there's not any request for restitution then? Okay.
No, Your Honor.
All right, sir, please, did I swear you in?
Yes, Your Honor.
Okay, and so you heard the plea that was placed on the record, correct, sir?
Yeah.
As to the amended charge of careless driving, how do you plead?
Responsible.
As to the amended charge of no proof of insurance, how do you plead?
Guilty.
Responsible or not responsible?
Then, Judge, I believe it's a no insurance, Mr.
Oh, I'm sorry, that was saying as charged, okay. Oh. Sorry, I've white all over this thing here. As the no insurance, sir, how do you plead, guilty or not guilty?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
You understand that there could be some additional sanctions from the Secretary of State.
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No, Your Honor.
All right, and counsel, if you can please write to your client as to the no insurance.
I'd like to direct your attention to August 28th, 2025, with you operating a vehicle in the city of Riverview. And at the time you're operating without any insurance on it, correct?
Yes.
Satisfied, Your Honor.
All right, did you pick him up on him? Okay. All right, the court is also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea to the amended charge of careless driving and to the no insurance charge. And counsel, you're asking for immediate sentencing?
Yes, Your Honor.
And what would you like the court to know?
Your Honor, my client's not on probation or parole. He doesn't have, in my knowledge, any significant prior criminal history. He is deemed employed. He has a valid driver's license. Judge, in this circumstance, I'd ask him to be admonished with cost and fines and if necessary, payment plan. Thank you, Your Honor.
Sir, do you have valid insurance on your vehicle now?
I do not. I'm getting ready to sell it.
Okay, and how did you get here today, sir?
I got dropped off.
Are you for sure you got dropped off?
No, I drove.
That's what I thought.
Okay.
So, sir, you've already gotten in trouble once for driving without insurance. Why do you keep driving without insurance?
I'm getting ready to sell the vehicle.
That doesn't answer my question. You continue to drive without insurance. As mundane as you may think it is, as ridiculous as you may think it is, I don't know if you do or not, that this is a crime. The state of Michigan says it's a crime, sir.
Yes.
You have to drive a vehicle with insurance. If you get in an accident, insurance is supposed to help the other person if there's injuries or damage or whatnot.
Right.
Okay, or even yourself. So every time you're driving a vehicle on the road without insurance, you're risking a whole lot of financial liability, sir.
I understand.
But you seem to not care because you seem to keep driving without insurance.
I will get it as soon as possible.
Well, sir, this is from August 28th, and you still don't have insurance, and we're 3 months later.
I can get it today if you need.
Well, it's not about me needing it, sir. It's about you needing it to legally drive a car.
Yes.
If you can get it today, why haven't you gotten it over the last 3 months?
Financial issues. I can pull it out of my rent money and get it today.
Or, sir, how about not drive? Where do you work?
Tom's Family Auto Care. I have to drive for a living.
Does your employer know that you're not insured?
Yes.
So, sir, if you have to drive for a living, you don't drive without insurance. So I'm not sure how you're going to get insurance today without your vehicle, because you can't drive that vehicle out of this parking lot not having it insured.
I can do it online.
Okay. The court's going to order a $200 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $425 with no insurance. $200 cost from careless driving, for a total of $625. So given that you're going to go pay your insurance today, how much can you pay per month? What day of the month works best for you?
I can do $100 a month. 15th.
December 15th?
Yes.
Do you like giving money away, sir?
No.
Then stop driving without insurance, because that's what you're doing. You're giving your money away to the court. All right, make sure, do not drive out of this parking lot.
Yeah.
They will be watching you, so do not drive. You don't have valid insurance. We cannot let you drive without valid insurance. We cannot knowingly let you violate the law.
Thank you,
All right, thank you. Have a good day. We are recalling the matter of the City of Riverview versus Alicia Trombley, 251307.
Good morning, I'm in DiSanto Court, David Burr, some Mr. Trump.
All right. Good morning.
Good morning.
And your name again for the record, please.
Yes, Alicia Trumpet.
Okay. And so, counsel?
Your Honor, it's the same plea agreement. I did speak to the prosecutor before today's date, so that was kind of, we had already arranged that. The only thing, I don't believe, I know it's up to you, Judge, but the only other thing that's not on the plea form, I know that it's honestly up to the court, but I know that people don't object to fines and costs only if the court's inclined, obviously, but he didn't put it on there. I just discussed it with him.
Okay, and so counsel, I need you to I understand it may be the same plea, but for the record purposes, I need you to place it on the record, please.
Yes, Your Honor. Your Honor, my client's going to, in exchange for a dismissal of the original count, my client's going to plead to an added count of disorderly conduct in this case.
All right, and so, ma'am, please raise your right hand again. Do you solemnly swear from the testimony about to give this matter be the truth, the whole truth, and nothing but the truth?
Said
And you heard the plea that was placed on the record.
yes,
And as to the amended charge of disorderly conduct, how do you plead?
guilty.
You've gone over your advice of rights with your attorney, correct?
Yes,
And you understand all of those rights.
yes, I do.
And you also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You've gone over the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No, Your Honor.
Counsel, if you can please vote to your client. Mr. Carmen? Just a moment.
Sure.
Mr. Carmen? Jake, can you please ask Mr. Carmen to come back in here, whether on Zoom or in person, please?
Michael A. Carmen, P73824, about the prosecution.
All right, thank you. And counsel, if you can please vote to your client.
Yes, Your Honor. Your Honor, date and time, please. I'm sorry. Okay.
August 28th.
Thank you, Your Honor. Currently on August 28th, 2025, you were in the city of Riverview, is that correct?
Yes, I was.
And you were delivering food that day?
Yes, I was.
Okay, and to where?
To a day,
To where? To a daycare
to a
center?
daycare.
Okay, and at the daycare center, there you removed a stroller that didn't belong to you, is that correct?
Yes, I did.
Okay. And let's see, that daycare was open to the public, is that correct?
Yes.
Okay, all right. Judge, I know that's sufficient for the original charge, Judge. I don't know if the court needs additional information.
Court will accept the plea as knowing, or I'm sorry, counsel, Mr. Carmen, are the people satisfied with that factual
Yes, Your Honor.
basis or no?
People are satisfied.
The court will accept that plea as knowing, voluntary, and factually accurate and dismiss the original two charges per the plea agreement. Ma'am, your attorney worked out a really good deal for you because quite honestly, I'm not sure why somebody would steal a stroller that doesn't belong to them and then resell it on Facebook. So counsel, I think for those reasons, I need to not go with immediate sentencing today and set this matter for sentencing.
Oh, okay, Your Honor. There's a little bit of extenuating explanation of what we can do with that at sentencing, Your Honor.
Oh, you can go ahead and tell me now.
Your Honor, when my client was present at the scene, there was a variety of clothes and strollers, and they appeared to be for donation purposes. She asked somebody at the daycare if those items were allowed to be taken, and she took one of the items, not realizing that the person probably didn't have authority to say anything about it. But there were a bunch of items out for sale. Judge, she delivers there all the time. They know who she was. She actually met with the police officer in this case and handed the stroller. So it's kind of a weird set of circumstances. I see the court's look, and I understand that it's a weird set of circumstances, which is why we entered into a plea instead of setting a trial date. But I'm just saying, Judge, it was a little more extenuating than her trying to just secret the cart out of the daycare. So I'm just letting the court. So
Okay, well, and the court would also think that if she is somebody that's been there and delivers there frequently, that, you know, especially having the stroller have the name of the child still on there might be a clue that that was not up for that, but we'll address that at sentencing.
and
Okay.
okay, thank you. Thank you, Judge.
All right, bond and conditions are continued.
Thank
Please stop over at probation, then you can coordinate that with your schedule.
you, Judge.
All right, we are on the record in the matter of the state of Michigan versus Christopher Skelly, 251327.
Ready, Your Honor.
While we wait for that contestant to come up, I must say theft of a stroller is indeed new. You're right about that, Michael, in the chat. But it's Michigan. I'm surprised because they do weird things. I'm surprised it's not like theft of some kind of vehicle or something like that. Anyways, back to Judge.
Afternoon, good morning, we're still morning. All right, and thank you for addressing appropriately for court. Today is a date scheduled for sentencing on your client's plea to two amended charges. One is attempt controlled substance use. The other is attempt possession of controlled substance. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, there are no additions or deletions. There are two minor corrections. One is that the report indicates that the pills in his possession belong to his grandmother. They actually belong to his sister. And the other is the location of his employment, which is actually Romulus.
Romulus, Michigan.
I'm sorry, sister, okay. Was it sister's car?
No, no.
Okay, all right. Okay, and council, as to the recommendation,
We concur with the recommendation, I think the probation is, appropriate in the circumstances. I'm sure he will probably earn the opportunity to be released somewhat early. They are recommending that if he granted the 7411 status, we're asking the court for the opportunity to take advantage of that. And he does understand that that will be completely within his purview, whether he gets that or not, depending on, whether he complied with all the conditions, and he assures me that he will.
all right, and sir, if you were to test right now, what's in your system?
Nothing. Your Honor.
All right, and so council, it appears for some reason that only the attempt controlled substance possession is eligible under 7411 and not the attempt controlled substance use. And it says only for count one.
That is what the report says.
Right, and so I'm slightly confused on that. So sir, who were you helping get home from work?
His name's Damian Daughtry.
Oh, yes, I think we've had that person here before. And so you're helping the wrong person. So that person had the crystal meth?
I guess that's what it was. Yes, Your Honor. I didn't know the person. He was coworkers with my friend at the time. And I was helping my friend get home, and he asked me to take him home too.
Okay, so I guess my question is this. Why does it matter? It says that the pill in the car belonged to your sister. And then, but then you're saying that you just helped the wrong person out. And then apparently it sounds though the pills belong to the wrong person.
It was one Tylenol 3, and it was for my sister. She has her own script for him because she had bad ear problem. And I can prove that.
That was in addition to the other junk stuff.
Yes.
Oh, in addition to the other stuff. Oh, okay, that makes more sense. Well, what happened to your matter in 2016 out of Van Buren for felony dangerous drugs? Was that dismissed?
I never had anything with that. I don't know what that is. I've never. Yeah.
All right, so I'm not quite sure why this isn't showing eligible under count one or under count two, because I believe that that is permissible under count two. So I'm going to order, and I'm going to order this. And if for some reason it's determined that that this conviction is not eligible under count two, then it would not be eligible under 7411. Okay. So, but counsel, does that change the plea that you have for your client?
No, Your Honor.
Okay. The court will note after hearing from counsel, hearing from Mr. Skelly, reviewing the report, the recommendation. That the court does find there's reasonable grounds to pardon MCL 769.5. The court also finds that the following sentence is in the best interest of justice, is reasonable in proportion to the seriousness of the matter, taking into account the seriousness of the matter and the circumstances surrounding Mr. Skelly and the legislative guidelines. The court's going to order 18 months probation. You're eligible for early discharge. You're also eligible under 7411. And I'll go over the early discharge in just a moment. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, whether in person, in writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status, not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can further assist yourself in providing coping mechanisms to maintain sobriety and hopefully prevent this matter from happening again. If you go to treatment and they indicate you don't need treatment, then they have to just submit something to probation. You're to participate in the fan meetings once per month. The rehabilitative goal for that condition is so that you can have this additional support to maintain sobriety and any recovery resources, as well as 5 days on the court workforce, each count of those. So that's a total of 10. The rehabilitative goal for that condition is to help you further develop life skills and give back to the community. Any questions regarding those conditions?
Okay.
The court's going to order as to count 1. The court's going to order a $500 fine, $100 screening assessment fee. Supervision oversight fee is $900. That's $50 a month at 18 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. Workforce is $200. It's 5 days at $40 a day. That's a total of $2,125 for count 1. Count 2, the court's going to order a $500 fine. I'm not ordering a screening assessment fee or oversight fee because it's the same case. I've already assessed it. $200 cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50. $200 for the court workforce. It's 40 days. Sorry, $40 a day at 5 days. So that's a total of $1,025. For a total between both of these of $3,150. Which is a lot of money, sir. But just so you're aware, the maximum fine on count 1 is $2,000. And since it's an attempt, it cuts it in half to be $1,000. I charged you $500. And the possession or the controlled substance use max is $1,000. Attempt is half, so I gave you the $500. Okay, you're welcome. So I'm going to have you set up a payment plan with probation, and then, sir, as I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've been in good faith efforts or making full payment. Okay? Thank you.
Your name?
Eric.
So we need Emily. So we set,
Yeah.
we set a sentence date. After you pled guilty to failure to submit to testing, you were going to go to your doctor. Did you go there?
I did. It was yesterday.
Did he give you a report?
He gave me just basically like a note. I tried to
Do
read.
you have it with you?
I sent it to Emily this morning. It was just like I saw you yesterday, though it wasn't much. So I did reach out. They don't know if there's like 9 to get you a report. She's on there. And then they gave me a prescription for something that she said was fine.
So is he saying that you've got shy bladder syndrome?
That and it's hard for it.
All right, let me get her in here. And we'll see what the letter says.
It was basically I saw you yesterday. That was just gonna show you much.
Well, that isn't enough.
I know it's not, that's why I said I reached back out already.
I need shy bladder syndrome diagnosis.
You did say it a few times, which is not, no,
It just says, I saw you
pretty
yesterday.
much. I saw you meet this person on the 24th.
Let me see what we can do here, okay? Just give me 1 second. See. If you need those or not. Unless I keep a couple up here, I could. Okay. Yeah. All right, so first of all, let me tell you something. You have a right to a lawyer. I'll be happy to provide you with one at public expense if you would like one. Would you like a lawyer to represent you?
Yes.
Pardon? Okay, so let me see what she has to say. Do you have anything to say?
No. They have to, go in.
All right. Why don't you have a seat? Just have a seat until she gets back. Okay? Thanks. You can sit right there at the table if you'd like. See. All right. Do we have this other gentleman's case here, John, or not?
Yes, he has a case with the state prosecutor field.
All right, recalling Eric Stefan Kish, 25F 244-490. Mr. Sino, your name?
Emily Tessino?
Sir, your name?
There it is.
All right, you still wish to waive your right to a lawyer and you don't have anything to say? He says he got a letter from his doctor just saying he was there. That wasn't the point.
That's what I said. I was, I think I responded and said he didn't give you any other information. He said that he gave him a prescription and I looked it up and it, or he's giving you a prescription. Yeah, so I looked it up and what it says the prescription is, does relate to the testing issue.
Does?
Yes,
It's gonna help him urinate.
yes.
Well, then let's set this for sentencing again. I'm sorry. If you want to go back and get the diagnosis of shy bladder syndrome, I'll require DNA. Is that where you're testing primarily?
Yeah.
And all his testing has been fine since. He went the 3rd, the 8th, 12th, the 16th, the 18th, and the 23rd.
You've been testing all those times?
I that's every time. I only missed the one due to this. I go back a lot of the times, like I'll go in the morning and usually go and pop back up later, but
Look, let's just do this.
Sunday it took 3 times I was there.
So all those tests have been negative.
He's on the sober league as well.
Good enough. I'm gonna assess costs of $50. You pay that now, I'll keep you on probation. Just make sure you're going, okay? If not, I'm gonna need a diagnosis of shy bladder syndrome, then I'll have them do a pat-down search. Okay? We didn't advise them to do a pat-down. I remember doing that
We talked about seeing if it helped, but we didn't.
Okay.
So I'm hoping that the medication helps and.
Good enough. Good enough. Thank you. Good luck. Thanks a lot. Have a nice Thanksgiving.
clevelandclinic.org, shy bladder syndrome, also known as paresis. Shy bladder syndrome is a social anxiety disorder making it difficult or impossible to urinate in public restrooms or by people nearby. People with shy bladder avoid using toilets that aren't in their homes. Untreated, this condition can lead to urinary problems and difficulty with work and relationships. Therapy can help. The Cleveland Clinic, ladies and gentlemen.
They changed it from a requirement to a strong recommendation, which I don't
Hang on.
know then. But it should have been, unless I gave you the wrong floor, which,
It was dated today.
okay. Yeah, I may have signed the wrong form. I double check it, Judge. Make sure I did print the sign.
I mean, let me take a look. Give me 1 sec.
Okay.
Mr. Muhammad, how are you this morning? Good, thanks. Wait. I want you to come here, please. Ma'am, your name?
My name is Lexi Dan, Your Honor.
Whoever has that phone.
You have to take that out of here, please, sir.
Yeah.
If the defendant, Mr. Muhammad, your name?
Good morning, Your Honor. Muhammad, happy people.
If the defendant fails out of the sobriety or specialty court due to poor performance, commits another crime while on probation recommendation, or the judge finds sufficient cause to terminate probation, then the balance of the year or 1 year must be served in jail, no work release or waiver.
Your Honor, I may have printed and signed the wrong form. Can I double check that?
Yeah,
My fault. I don't want to get Mr. Muhammad in trouble.
Well, nobody's getting anybody in trouble. I just still don't feel comfortable if that's the best we can do. So we'll have to go to the exam. The exam's today, right?
So Judge, that was amended to a strong recommendation, and that portion is not part of the sentence agreement. I'm assuming that form is the old copy.
No, it is it does say strong recommendation on the top. So I think the idea is, Your Honor.
Guys, I don't mean to be rude. How can I read this different than I'm reading? I can't.
Judge, it's not a sentence.
Listen. You said, under strong recommendation?
Yes. It's.
Hang on.
So if I could, Your Honor, I think the idea, okay, sorry.
You know what the idea is? I am not going to ever put myself in a position where somebody says the judge sanctioned this plea agreement and then didn't follow through. I want you to hear me clearly. Nobody's ever going to be able to say that I took a plea. There was an agreement in place. Now, it might say strong recommendation on the left, but any judge reading this, quite honestly, including this one, if the defendant, it's a strong recommendation. I'll give you that in bolds. If the defendant fails out of the sobriety or specialty court due to poor performance, commits another crime while on probation, recommendation, or the judge finds sufficient cause to terminate probation and the balance of the year or 1 year must be served in jail, no work release or waiver. Now, what does that mean? I know what it means. I don't feel comfortable doing this, guys. If you want to redo this language and just say then the prosecutor's office, if the defendant fails out of the sobriety or specialty court due to poor performance, commits another crime while on probation, or the judge finds sufficient cause to terminate probation, the Wayne County Prosecutor's Office stipulates in Wayne County Prosecutor's Office recommends that the balance of the year, or 1 year, should be served in jail. However, the Wayne County Prosecutor's Office leaves this to the court's discretion. I mean, I'm not going to go through with this, guys. I told you, I mean, I'm going to give you the example again. Somebody is 95% compliant and they screw up at the end. They have an addiction. They've done a good job, but they lost it again at the end. I've seen it. It happens. I'm not going to have somebody tell me you have to give them a year in jail. I still go back to what I said. And look, it's okay that we disagree. Maybe you guys need to go to the Wayne County Circuit Court, sobriety court, probation. I have no problem with that. You can waive the exam. I happen to think ours is as good as any around, but I'm a little biased. So if that sounds arrogant, forgive me. But I will do this under these circumstances with this language in it, unless it's clear and unambiguous that this is in the court's discretion. And to the extent somebody can't say that, I understand. It's okay. We'll just agree to disagree. But I can't have somebody tell me this says that it's a recommendation. I realize it's a strong recommendation. And then, by the way, you got on the back here, courtroom APA must be notified if any of the 1 year jail sentence triggers are committed. Now, maybe there's judges that'll read it more liberally. God bless them. It's okay. Everybody doesn't have to agree with me. Everybody, every day, people don't agree with that. It's okay. I get it. They don't have to. Ms. Don, I am so sorry. I don't know what to tell you. You guys can work on this if you want. You can pen it in. You can redo it. You can do what you want. If the office is going to say, Judge, that's the best we can do, then I'm going to say to you, I'm sorry, I'm not doing it. We're going to the exam at 11 a.m. today.
Judge, I may, just in regards to that portion, we are leaving that to the discretion of the court.
You got to write it in here. I'm not going to go searching for transcripts. This does not look like.
But that's why it was written as a recommendation, not.
You wrote it as a strong recommendation. You put it in the caption, but then it reads like the judge has to do this. I mean, if you can't, listen, I'm not trying to pressure anybody or make anybody feel bad or anything else. This seems like a nice lady here. I'd love to have her in our sobriety court. I think she would be a great candidate. But I feel so strongly about this, and it's not some kind of just an argument. I don't need to argue with anybody at my age, but I just can't do it. So you guys are either going to have to fix it or we're going to exam at 11. Sorry.
No problem. If we have it back, I mean, hopefully we can fix it.
Okay. Hagen Lee, John, can you handle that, please? Hagen Lee Trackwell at 24B714693. Again, Mr. Muhammad, I want to be clear. If you guys just don't want to do it, it's okay. You're not hurting my feelings. You're not.
I understand.
It
goes through my supervisor.
I know, I get it. Come on up to the podium if you would, Mr. Trackwell. Mr. Trackwell.
Yes, sir.
Where were you?
I was just calling to do some things.
All right, okay, let me talk to your lawyer. Counsel, your appearance.
Good morning, Attorney Corey Westmoreland, Great Mill, well.
Okay, so you didn't show up here for your date on October the 23. So why didn't he show up for his November 23 date, Counsel? Can you tell me?
Your Honor, I just had my car repo. I had no way.
Where do you live? You live in Brownstown.
Yeah.
How far do you live from here?
Like 15.
All right, well, how'd you get here today?
I got a ride from my mother.
Why didn't you get a ride from your mother on October the 23rd, or take an Uber, or take a cab, or take a Lyft?
right before my car got repoed.
Calling Jessica.
Trying to make sure my girlfriend gets to her OB.
All right, I'm gonna let it go. You can't do this, son.
Yes, Your Honor.
You can't do this. You walk in here 5 weeks later. What if I wasn't here?
Yes, Your Honor.
That'd be rude if I wasn't here since October 23rd and then decided to come in to Monday and told you to come in. Counsel, there was no, disposition on this. The charge is failure to refrain from consuming alcohol or drugs, testing positive for cocaine on a chemical test. That's count 1. It's actually an amended show cause dated October the 16th. And then count 2 is failure to refrain from consuming alcohol or drugs, testing positive for alcohol and marijuana on a test of October 16th. So those are the 2 counts. Ms. O'Donnell, your name. Good morning to you. How is he going to proceed?
Yes, Your Honor, after speaking with Mr. Trackwell this morning, we are prepared to waive any sort of contested hearing on the 30th.
Is that what you want to do, sir?
Yes, sir.
You have 1 prior technical violation. This would make 3. I just want you to understand, you could get 15 days if you plead guilty to both of these. That would be 3 technical violations. Do you understand that?
Yes,
Did you sign an advice? Did he sign an advice of rights form today? You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena power of the court to bring in those witnesses. If you plead guilty, now wait before we go any further. I'm just going to orally advise you, then you can sign the form, okay? If you plead guilty, you're giving up all of those rights, including your right to a contested hearing. You have the right to remain silent at that hearing, and if you do, that silence would not be held against you. Do you understand?
Yes, sir.
If you plead guilty, we're going to have a disposition hearing, but we're not going to have a hearing as to these 2 counts if you plead guilty. Do you understand that?
Yes,
Any questions before we go on? You understand everything?
yes.
There's the count 1 that you fail to refrain from consuming alcohol or drugs testing positive for cocaine on October 6th of 25. How do you plead?
Guilty, Your Honor.
Did you test positive on a chemical test on October 6th of 25 for cocaine?
Yes, sir.
Did you consume cocaine within the, say, preceding 72 hours?
Yes, sir.
As the count 2. Did you fail to refrain from consuming alcohol or drugs testing positive for alcohol and marijuana on a chemical test of October 16? How do you plead?
Guilty.
Did you test positive for alcohol and marijuana on that date? Hang on 1 second, just listen to my question. And did you consume alcohol and marijuana, say, within the 3 days preceding that, at least the alcohol?
Yeah.
Did you consume marijuana, say, within a week of that date?
No.
When did you consume marijuana?
It was probably a week prior from me seeing my probation officer, so.
Wait a minute. Let's talk about the test date of October 16th.
Yeah, marijuana was still in my system
Slow down.
from being.
Slow down. When did you last use marijuana? I sent you in this case on October 15th. I see. But I told you not, Judge Hessen told you not to consume alcohol or marijuana on July 17th to 24, and you absconded, right? Right?
Oh,
On the bond.
yes.
You were told not to drink alcohol or consume marijuana, correct?
Yes.
And then you absconded for the longest time, right?
Yes.
And you realize those bond conditions were still in effect, right? She never lifted those, did she? She never told you you
No.
could use marijuana and drink, did she?
No.
Are you on probation or parole for anything else?
No.
Anybody force you to plead guilty?
No.
I'm gonna find you guilty if I find the plea has been made voluntarily and understandingly. Please accept it to being positive for cocaine and positive for alcohol. Cocaine being on October 6th test. Count 2 for alcohol, October 16th. there's still enough there to show that you at least violated a bond, but at least you're guilty of consuming alcohol. Now, look, this case was disposed of, or at least by plea, on October 1 of 24 after, I'm sorry, as a bench trial. And we are still wait a minute. I sent you October 15 of 24.
Yes. I only went for one drink or something. Sure, yeah.
He was sentenced to probation October 15th of 2024. He was on probation.
Right, and these tests happened on October 6th of 25.
A violation was issued back in September. He went into warrant status, turned himself in. He extended his probation 3 months. And then I issued this other violation October 23rd of 2025. He didn't appear. It was issued a warrant and he turned himself in today on that. And Judge, if I could, regarding the test on October 16th, he did go back after the fact, after I issued it, and did pay for the lab. He didn't pay for the lab confirmation on the marijuana, but he did pay for it on the alcohol. The alcohol confirmation did come back positive. ETG was greater than 10,000 and ETS was also greater than 10,000, Your Honor.
This is becoming complex, Mr. Trackwell. What do you have to say? Anything?
Your Honor, I would like to know that Mr. Trackwell did check himself into Corwell Lane Mental Hospital. He was there for approximately 4 days.
When was that?
I believe the 25th
Of what?
or the 22nd of this month.
Were you back in September at a mental health facility? Listen to my question. On September 2nd, were you in a mental health facility on or about that date? September 2nd?
I don't recall. I don't recall, Your Honor. I was just, they took me to court with mental health. I was there for like 4 or 5 days.
And you're saying, but there's a note in here that you went to a mental health facility in September.
I probably did. But I just was there recently.
I understand. What else would you
Your
like?
Honor, he currently is looking for gainful employment. He's having a tough time doing so, being that he doesn't have a car. But he's looking to get his life back on track. He walked himself in here today, receiving us this was pending. He wants to clear this up. He does have a strong family support. His mother and his girlfriend are currently in the courtroom.
Where? You're his mother? Come on up here. I don't usually do this, certainly not with somebody who's in their early 20s, but I want to talk to you. How are you?
Okay, how are you?
Good. Your name?
Janet Trackwell?
You got to get your son on track, so to speak. Okay? He's not doing it. I believe you. I don't know the extent of his issue, but he's ignored us. And he's not doing what he's supposed to do. Did you graduate high school? Do you have a GED?
No. I took the test.
That's great, he went up to. He's had some history between myself and his father. His father does have addiction and mental health issues out of state, and he's not been consistent within his life. So
What do you think?
I'm very concerned. If we go back and forth, Hagan will do okay for a little while. He'll then violate probation, I'll issue a violation. He doesn't show up for the hearing. He'll then go on warrant status for a couple months and then he comes back around again. I am very concerned. And again, the last report I have from his mental health treatment's back in August. So I don't know if he's been.
Has he been going?
no, he's been avoiding everything. I sent a message just last week or
He's been what?
I just sent a message to Jessica a couple weeks ago through email because I have the concern that he continues to blow everybody off up under any kind of authority who's trying to put him on the right track.
Hagan, have you ever been to jail?
Yes, sir.
Where?
Marty County, Tennessee.
How long?
So went to prison.
Pardon?
Before my dad went to prison.
Yeah, but I'm worried about you right now.
Yeah, it's locked up in Murray County, Tennessee,
How long?
for like a week.
Was that a county jail?
Yeah, it was
What was it for?
for that of Plan B from Kroger.
Why aren't you going to mental health treatment?
Just got my services set back up. I have my case
When did you
manager.
last go to mental health treatment?
I think last month. Was it last month? It's been a couple months.
What are you fooling around with cocaine for, son? You can't do this.
It's got-
Well, you can be the leader.
Yes, sir.
I mean, I don't want to make you feel bad, but they're only giving you one of these things called life. And you're not working, you only have a 10th grade education. You're violating left and right. You're not doing what we told you. I mean, I'm surprised. Can I tell you something? The more I look at this file, the only reason I think I gave you another chance because you've blown us off for so long is because I wanted you to do some mental health treatment. I thought that would help. No. Let me see. No, get the other one that I got like this. Okay. Well, let me see. That might be it.
That's the one that's it.
Thank you. I don't think I can do anything here other than send you to jail, and I don't want to send you to jail. What do you think?
I don't know what else we can do for him at this point. I am happy that he's back with his mom. I think that is a good support system, but he'll stay with her for a little bit and then he leaves and she doesn't know where he is for a couple months, couple weeks. So the back and forth, if he stays with her, I think things are a little bit better. She at least tries to hold him a little more accountable, but I don't know if he'll ever stick with that though. He hasn't shown in the past that he has.
Who says he paid all his fines?
I believe it's $145 still.
We pay that.
Not today, but I've been paying everything.
Judge too, I do want to note, this case is taken under the domestic violence status as well, the special status.
Well, I don't have any choice but to revoke that. 769.4A status revoked. I know I hadn't done that. Conviction entered. I'm gonna sentence him anew. I'm gonna need a first page of a misdemeanor register. I'll be right with you, Ms. Tucker. My apologies.
Thank you, Your Honor.
So I'm gonna sentence him anew, I guess, and you know, I don't know what else to do with it.
Yeah. You give me one more chance.
I think you told me that, but no.
Clean up, do better. I think the steps I need to do, we need to run it. I love it.
I could sit here and never send anybody to jail. It would make my year. But I can't let this go on. I cannot let this go on. All right. All right, so I'm going to sentence him anew. Is there anything else anybody wants to say? So I'm revoking his status, entering the conviction. I'll sentence him now. Does he have any credit for time served coming for court work or community service? Let me see.
24-hour community service, Your Honor.
Anything else, counsel?
Your Honor, it sounds like he's back home where he does have some direction and some oversight from his mother. I would just ask that be taken into consideration to potentially give him one last opportunity on probation.
There's no way you can pay the $145 today, or $200 is what I'm gonna check. We're not open Thursday or Friday. Here's what I'm doing. Did I let you finish anything else?
So.
Lisa, please listen carefully. You do such a good job on these, but I want to make sure that this just says, I'll tell you in a second. 100 fines, 100 costs, $200 in 93 days, credit 4. So you're going to serve 89. I will suspend 75 days if the fines and costs are paid. The $200 is paid by Monday. So you're going to only have to serve 14 then. So if the defendant pays fines and costs, we'll suspend 70, not 75. And that's a gift. And I'm going to tell you why I'm doing this, and one reason only. Because I'm still hopeful that you're going to get yourself with your mental health issues so much. You cannot do this. You're ruining your life, and you can do it, but you need to get some help. There's nothing wrong with acknowledging we have a problem and moving forward and trying to correct it, or at least get it under control. But you're not treating, you're doing cocaine. That's what I'm going to do. That's a gift, son. You're in custody. "21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal." Ma'am, I'm sorry. I really am. Have a good day. Good luck.
You're here for first appearance accused of one count of driving while license suspended or revoked knowingly. Mr. Jones, you have a couple of young ladies in the courtroom on your behalf. Mr. Jones, based upon the text messages exchanged between Mr. Mitchell and Mr. McDaniel this morning, I think Mr. Mitchell may have an announcement in your case. Is that correct, Mr. Mitchell?
Yes, Your Honor. I was able to look at the information that Mr. McDaniel sent the both of us, and I looked up his driver's license info on the FLHSMV website, and it does show that his license is valid. So it's not in our system yet. I won't be able to file an official no information, but I will announce a dismissal on the record.
Thank you, Mr. Mitchell. So, Mr. Jones, what Mr. Mitchell's done ever since he's been in Jackson County handling this caseload, probably a year and a half, is if someone has no prior driving suspended licenses and they charge with one, and they get their license before the court date, get everything straightened out, he commonly will dismiss the criminal case. I think yours may be the first one that's gotten it straightened out before first appearance.
Yes, sir.
But it's fairly common for people on the first offense to figure out what the issue is, insurance, fine, whatever, unpaid ticket, and resolve it before the court date. So since your case has been resolved, you've gotten your license straightened out, and since it was your first offense, Mr. Mitchell's announcing a dismissal of this charge. Is that correct, Mr. Mitchell?
Yes, Your Honor. I just don't know if he
Did I
was
misexplain anything?
I was just saying, I don't know if he has been given any civil citations in addition to it. If so, those need to be addressed.
No, sir. I got a warning. That's it.
Okay. Mr. McDaniel, anything else from your perspective?
No, Your Honor. Thank you.
So in light of the pending dismissal, Mr. Jones, I'm going to give you an ROR. That means you're going to get out of jail this morning. Mr. Mitchell's office will dismiss this case next week. Once it's submitted to them, again, their office is closed today for the state holiday. So Mr. Jones, you'll be released this morning. So ladies, what that means is they're going to process him out. By the time they get him processed out and back in his regular clothes, usually that's about a 30-minute process. He can be picked up at the jail in roughly half hour. Someone going to be able to pick him up? They've got transportation covered. They'll be there to pick you up. Mr. Jones, do you have any questions?
No, sir. Thank you.
Wish you the best, sir. Thank y'all for coming.
Thank you so much, sir.
We have Michael Whitaker next. Mr. Whitaker, come on up, please. Mr. Whitaker, good morning. Mr. Whitaker, you're here because you've been accused of driving while license suspended or revoked also. However, yours is fourth or fifth offense, depending upon how you look at it. In your case, it's a failure to appear warrant. I'm appointing the public defender's officer to represent you in this 2020 case. I'm going to ask that you listen to Mr. McDaniel, your attorney, and we'll see where we stand, sir.
Your Honor, I spoke to Mr. Whitaker, and he just, he wants to address the court before we do anything.
Okay, Mr. Whitaker, go ahead, sir.
I was just trying to see what, in a way possible, that I can be able to get out in it. Like, I mean, I know the case is 5 years old, and I know I failed to appear, and I know y'all have to do your job or whatever. You feel me? Well, all I'm saying is, like, I just don't know what to say right now, because at this point right here, like, 30 to 60 days or however, whatever your decision is to put action to whatever my crime that I appear to do. I was just trying to see, could you have a heart to just look at the circumstances or to understand, like, it's the holidays, and I know you have family just as well as I have family. I have kids that ain't gonna see their father for the holidays, and I have a job, and I'm gonna lose my job from this place for $38 an hour, sir.
Mr. Whitaker, let me ask you a question. Let me ask a question. I know that you were arrested for felony driving with suspended license based on your fourth or fifth. And that's how we finally got you back, because you got arrested in a neighboring county, and they held you over there for several days, it appears, and then we finally got you over here after 5 years. My question for you is, I don't know how you got out over there. Did you post a bond in that county, or were you released in some other manner in that county?
Judge, Madison County is pretty consistent that they don't hold anybody for that. They give him ROR immediately upon arrest and call the sheriff's office to come pick him up. So he has 7 days jail credit.
So he didn't go to jail on their charge. He only went to jail on our charge. Is that right, Mr. McDaniel?
Well, they give him a notice to appear, when they get to the jail, and it was an ROR, and they sent so he's got 7 days jail credit on this.
Okay. So this warrant was issued back in 2020, and at that point, we put no bonds on failure to appear. I put no bond on all failure to appears. Since then, Mr. McDaniel, you've made an argument probably 2 years ago that if they were never arrested and they hadn't been posted bond previously, and that they weren't sent a notice, other than, in this case, allegedly sent a notice, but that there's no evidence they received that notice that they were entitled to a bond. Mr. Mitchell, do you agree that in this case, Mr. Whitaker is entitled to a bond, even though the original warrant 5 years ago says no bond?
Yes, Your Honor. I'm okay with, I'm in agreement with him getting a bond.
Mr. Whitaker, I'm going to set your bond at $5,000 cash or surety. You've got a condition not to drive a motor vehicle. As far as anything other than that, that's all I'm not going to do anything. You still may be looking at the same sentence if you're convicted of this, but you haven't been convicted and you've got the right to post bond. Your bond is $5,000. And again, you've got a condition, no driving at all. You've got a horrible driving record. It appears that you continue to drive without a license. You've got at least 3 convictions for that in the past, 1 charge within the last 2 weeks in another county. So that's your bond, and you get a chance to use the phone in a few minutes to try to post the bond. I'm going to ask the jail to give you a notice for your court date, which will be
January 5th.
January 5th at 9 a.m. Mr. Whitaker, do you have any questions, sir?
Yes, sir. If there's any way possible, I can that you have the ticket in front of you, the how much it costs or anything, sir?
It's a $400 fine if you get convicted.
Okay.
There's a fine in this case if you're convicted, but in your case, because of your driving record, there also may be a jail sentence, depending upon what happens in court. But you've got the bond set now. Any other questions?
No, sir. That's all. Appreciate you. Thank you for your time.
Have a good day, sir. We have Robert Merritt next. Mr. Merritt, good morning. Mr. Merritt, you're here because you've been accused of 1 count of trespass after warning and 1 count of third or subsequent petty theft. That's a felony charge, sir. Mr. Merritt, there is probable cause in the complaint, and I've also looked at your criminal history. Mr. Merritt, I think you're entitled to a bond, but let me see if the attorneys have any additional information they want to make sure I'm aware of. Mr. McDaniel, anything on behalf of Mr. Merritt?
Your Honor, I don't think he's gonna be able to post any bonds. I don't know if it's gonna matter, but I mean, you've seen the complaint and I know Mr. Merritt is, he's don't have any money and sometimes he probably does stuff, and I know the amount is probably $5 worth of food or something. So just take those things in consideration, but I don't think any bond's gonna matter, so.
Let me see what yeah, it looks like it's less than $10 in items. The problem is he's got a petty theft from within the last year or so.
Same kind of thing.
And then he's got three prior petty thefts. That's why it's charged as a felony. Mr. Mitchell, anything on behalf of Mr. Merritt, sir?
Just a reasonable
Or
bond.
anything on behalf of the state? Okay. Mr. Merritt, I can't give you a conditional release with the history you have, but I'm glad to set you a bond. Mr. McDaniel, I know that you said he may not be able to post it either way. Do you have a preference on, does he have a preference on cash versus surety?
You don't have any cash.
Mr. Merritt, I'm gonna set you a $2,500 bond on each case. It's cash or surety. Mr. Merritt, you have the right to go through a bondsman, sir, but your criminal history is what's getting you the bond in this case. Mr. Merritt, you'll get a chance to use the phone in just a few minutes, sir, to try to post the bond. And Mr. Merritt, you've got a condition of no contact with any Dollar General. Now, they've already got you a trespass warning at that one. That was issued before yesterday. Okay, that police department says that you were, and I just know what the complaint says. I know they're accusing you of that. So, Mr. Merritt, what I just want to be clear about is right now there's an order. I'm entering an order, a bond condition of no Dollar Generals at all. So it can be confusing. Can't go to any Dollar General while this case is pending. Once this case is over, then we'll see what happens. But right now, I need to keep you out of Dollar General because it appears they don't want you in those locations. Mr. Merritt, do you have any questions, sir?
No.
Have a good day, sir. Court date, it'd be a felony court date right now, which would be
January 6th, maybe?
I don't have that list back either. Mr. McDaniel, I don't have the new list back. Do you have that? We had to get it changed yesterday because it wasn't illegible. Do you have the court date?
Oh,
it's the same one you have. It's just when we tried to look at it, I couldn't read it because of color combinations. It was too dark.
January 6th, I believe it is. January 6th. I can look it up.
January 6th at 8:30. If you give him notice for that day, please, Corporal. And that brings us back to Mr. Pittman.
Oh, Mr. Pittman, come on in.
Mr. Pittman, good morning. Mr. Pittman, you're here back for first appearance again. Your cousin, Mr. Hudson's in the courtroom, sir. Mr. Pittman, the law enforcement, I held you yesterday because I didn't feel there was probable cause in that complaint for assault. They have since amended the charge, and they've now accused you of one count of culpable negligence. What that charge is, it's a misdemeanor offense, and they're basically saying, Mr. Pittman, that you're culpably negligent for taking your mother out of the facility she was in and putting her in an unsafe environment, an inability to take care of herself due to her medical or physical condition or mental health condition. That's what you're accused of. It's a misdemeanor offense. I have read this new complaint carefully. I actually went and pulled the culpable negligence statute to make sure I understood what the elements of the charge were. And there is, yesterday you wanted to represent yourself for first appearance purposes. Is that still the case, sir?
That is, Your Honor.
Mr. Pittman, anything you want to be heard on probable cause on the new charge of culpable negligence?
Yes, it is, Your Honor. Can I speak?
Before you say anything, let me give you this caveat. Mr. Pittman, we're being recorded. You're the defendant. Yes. If you talk about the charge itself, this recording could be played and used against you. So I would encourage you, do not talk about the charge itself, but if there's a legal argument you would like to make, I'm glad to listen, but I wouldn't talk about the allegations against you because you're the defendant and you've chosen to represent yourself at least up to this point. So is there anything you would like to tell me about probable cause or any legal argument you would like to make?
Well, I first would like to make a legal argument as far as an objection to these proceedings. Number one, I was never given my Miranda rights at any time. So I object on that ground first.
Mr. Pittman, Miranda only applies to in-custody interrogations. There's no evidence of any statements they're using against you or trying to use them against you. Therefore, Miranda doesn't apply unless they're trying to use statements against you. Had you accepted my suggestion that you get an attorney, you would know that, or your attorney would know that, but that's not a valid basis to object to anything unless they're trying to use statements against you, which they're not so far. Any other points you want to make?
Well, I anticipate that they will. So I've expressed that one objection. Okay.
Okay.
Objection number two. Objection number two is that my name is Randall Pittman. In 2003, 2007, I became a private attorney general for the state of California.
Your Honor, I'm going to object to this. This has no bearing on probable cause for this fact
Your Honor,
pattern.
I have a right to speak. I have a right to speak. And,
Mr. Pittman, you have the right to speak on probable cause, but that's what we're here for, is whether or not there's probable cause.
I have a right to make 3 objections. I'm just making 3 objections, and just let me do that, and then we can proceed. I'm a private attorney general of the state of California. I've been working undercover for them for about 20 years. And I am disclosing that information. So what that means is that this court has no jurisdiction over me because I'm a California private attorney
You're
general.
wasting our time. You're wasting our time. Even if you were a private attorney general, that has nothing to do with whether or not we have jurisdiction over you if you're accused of a crime. Mr. Mitchell, anything from the state regarding bond, sir?
Your Honor,
So
we would
I'll
just
move on
ask
to
for a reasonable, Mr. Pittman, we would just ask for reasonable bond under this situation and absolutely no contact whatsoever with his mother, Willie Ruth Pittman.
Mr. Pittman, I'm going to set you the standard bond I would for just about any misdemeanor charge. That's $2,500 cash or surety. Mr. Hudson, I apologize. I didn't give you a chance to speak on Mr. Pittman's case. I know you have some things to add on her case. Anything you want to add on his case? So, Mr. Pittman, your bond is $2,500. It's the same set on just about every misdemeanor. It's cash or surety, Mr. Pittman. You'll use the phone in just a few minutes, sir. You post the bond, you'll be released. Mr. Pittman, 2 more things. Number 1, I'm going to ask the jail to give you a notice for your arraignment date, which will be
January 5th.
January 5th at 8:30. Secondly, Mr. Pittman, you do have that still condition of no contact with your mother for the reasons I put on the record yesterday, and even more so now that you've been accused of a crime directly relating to lack of providing care for her. So you've got a condition of no contact with your mother, at least temporarily. Mr. Pittman, do you have any questions, sir?
Yes, Your Honor.
Okay.
I have paid for a 24/7 caregiver for my mother who was at the house when I was arrested. I did not know she was being arrested. If I had known, I would have made sure that the caregiver would have taken over right then.
Mr. Pittman, Mr. Pittman, you're commenting on the case that you're accused of, and I've told you that's a bad idea. I'm going to stop you because you're going to hurt yourself is what you're going to do. You need to talk to an attorney, a real attorney. You need to talk to a real attorney, Mr. Pittman, that's licensed in Florida, is my suggestion.
By white society. I'm going to ask
Your first appearance is completed. I'm not going to try to talk over you any longer. Have a good day, sir.
Thank you.
All right, that's right.
Okay.
Come on.
We'll talk to you soon, buddy.
So, Mr. McDaniel, is it Mr. Hudson or Dr. Hudson? Dr. Hudson is here. Mr. McDaniel. It's not on his case. He needs to be taken out of the first appearance room. Dr. Hudson, do you mind coming up, please?
Yeah.
I need them.
Judge, just a clarification, because you said that they amended it to this charge. Does that go away with the charge yesterday? The jail and me are both a little bit confused. Or is this a new charge on a new case number? Or?
Come on up, Dr. Hudson. So we'll clarify this first. Mr. Mitchell, what's the state's position on that?
I think from what we had what I've had discussions with the investigator in this matter is they amended the complaint for the yesterday's charge also and added this one in addition.
So it's going to go in the same case number?
No, the complaint doesn't say amended anywhere.
Oh.
So it's going to have to be set up as a separate charge. I found probable cause. So we got 2 complaints that's not amended. So he has 2 charges, one of which I found no probable cause. That's the assault with the ROR. The second charge is the one I found probable cause on. I've set the bond on today. So y'all may dismiss that assault if you choose to, Mr. Mitchell, but because this is not an amended complaint, it's just a regular complaint. It's not amended. It doesn't say amended at all. So if that was their intent, they didn't do amended complaint. They just did a regular one. But either way, we can get to where we need to go and get in court. Don't do everything else.
Oh, did you say ROR on that charge from yesterday? That's what the jail's telling me you said.
No, I didn't set it. Oh, you're right. I found no probable cause, but he waived that.
Yes,
sir.
sir.
Thank you for correcting me. I said 5,000 on that. That was an assault, but the only reason I did that is because he was waiving that right. So Mr. Mitchell, what's the state's position on that?
We could keep it as it is right now until probable cause is challenged. I mean, he's representing himself right now and he waived that.
I'm not comfortable with that. I wanted to hold him, Mr. McDaniel, because I want to give the state time to get the complaint correct. I don't think that's really fair to him to set a $5,000 bond on that assault, given he waived probable cause because he was trying to get a bond set. He wasn't able to post the bond, obviously. So I'm going to change that $5,000 bond to an ROR on that case. I guess it's possible the state will go forward with an assault. It's hard for me to imagine them being able to do that on a conditional threat like that. And I fully thought they would amend that complaint, but they didn't. They just filed a separate complaint. So to make it clear and try to be extremely fair to him, he's got a ROR on the misdemeanor assault. Probable cause was found only by agreement, not by fact. And he's got the bond I set this morning. So he's got a total bond of $2,500 cash or surety to clarify. Thank you. So Mr. McDaniel, Mr. Mitchell, this is Dr. Hudson. Dr. Hudson was here this morning. My understanding from Dr. Hudson, talking to him real briefly about just to see what his role was. He is the nephew of Miss Pittman and the cousin of Mr. Pittman. But Mr. Hudson, Dr. Hudson came to be heard. He has some information on Miss Pittman. So Mr. McDaniel, I know that you're trying to get her out and find out where to go. So Dr. Hudson's here to give us an update on what efforts the family's been able to make thus far. Doc.
Okay. Good morning. I'm the nephew of Miss Willie Ruth Pittman. My mom is her sister, but I'm also the cousin of Randall. We've been having issues, as this court knows, for a couple of years with him. And I don't want to seem negative, but taking advantage of her situation. As you can see, there's some mental issues with him as well, but she definitely has dementia and also mental health issues. It is hereditary. And so I've been trying to become her power of attorney. He has a power of attorney on her, as well as her health. And that's why he's able to do the things that he's been doing. We've had her in several facilities in Jackson County, and each time he goes and does something, either alienates the staff or just takes her out and takes her home. This time when he took her out, she was in Tallahassee, where I live, in a facility. And we were trying to get her stabilized, and I had my lawyer to go meet with her to see if she would allow me to become the power of attorney. She agreed at first with me there, and then she wavered and didn't agree. And then I think he came to court, and because she was in the facility, they dismissed the previous charges against him. And so he was able to go and take her out. I've been trying to get him stabilized, to get him a job and everything. I even gave him a vehicle to get to work, and he turned around and used that to travel and get her out. And so I just had a question. Can his power of attorney be overwritten, and because of her mental state, could someone else, she has two other sons, but they're not in a mental capacity to be able to do it as well?
There's two ways to essentially in Florida, there's two ways to get rid of a power of attorney. One is if the person granting the power of attorney revokes that power of attorney. It's called a revocation. She has to be competent to do that, and she has to do that in writing, just like she would the power of attorney. The second way you can override a power of attorney is called a guardianship.
Okay.
A guardianship or an emergency guardianship is where you, someone would hire an attorney. The attorney would ask the judge to create an emergency temporary guardianship, and that guardianship would override the power of attorney. Typically, that's going to have to be accompanied by some type of medical documentation, doctor's notes, doctor's recommendations, something to support it. Sometimes it may also have to be accompanied with some reason. Normally, your children are your guardians, so you have to have a reason to say, Judge, in this case, if your position is this, the child or children are not appropriate guardians, and here's the reason. So that's the two only ways I'm aware of in Florida to set aside a power of attorney, those two ways.
Okay. So would her other son, his Randall's twin, be able to request a revocation
Yes.
of his power of attorney?
She can, the revocation of a power of attorney is a simple form. She signs, it's got to be appropriately notarized and witnessed.
Okay.
It's got to be prepared. And then what that does is that gives her no power of attorney. And then she needs a power of attorney, arguably.
Right.
So if she chose to issue another one, she could sign one and then immediately sign the next one, naming whoever the new power of attorney is, whoever that is,
Okay.
if she decides to do that. But she has to be competent to do both of those.
Well, what if she's not competent to
If
do
she's
it?
not competent, then guardianship's your only option.
Guardianship, okay, all right.
So as far as placement goes, it sounds like even if he has no contact, the power of attorney that's currently in effect is an issue or roadblock in placement. Mr. McDaniels is trying to get her out. I would consider any type of release options to get her out. I've just got to have a place for her to go.
Right.
Okay. Any additional information that you need or any questions you have for the attorneys?
No, I'm just, thank you guys for working with her. I know it's difficult, and specifically in her mental state, because even with me, she's kicked me out of the room at least 20 times. And so that's why it's sort of challenging to get her to see what's in the best interest of her.
Yes, sir. Mr. McDaniel, any suggestions or advice in her case of where you want to try to go from here? We kind of handcuffed until we get placement options, or what are your thoughts?
My thought is just like that text I sent. It's the sheriff's office duty to contact DCF when there's an elderly person that's in danger. DCF shows up at their office and interviews her and talks to her, and then tries to find placement with them. They've completely skipped that step to basically bring her to the jail. You know,
that's not what the complaint says. The complaint in his case, the complaint in her case goes in great detail about what efforts the sheriff's department made, Mr. McDaniel, to try to find alternative placements. And I don't know it's as easy as you're portraying it. They according to that complaint, they went to a lot of effort to try to find a place other than jail, and they didn't have anywhere, is what I'm reading.
I read it as that they were calling the non-emergency number, and they were not, I mean, but if a person is just like a minor child is in danger, they'll take them to their office and they hold them there and they'll call the emergency number, not the non-emergency number report. They said the complaint that they reported it to DCF, but when you're sitting in their office, they'll have someone call them on the phone and talk to them and say, we've got this person here that needs assistance, and and they'll come out there. I did not see that happen. They brought her straight to the jail, and they did non-emergency calls. I agree with that, but they didn't do the emergency call, just like you would with any minor that gets arrested.
I think you're second guessing them, and I just don't know that's fair given the complexity of the situation. But I'm willing to release her to any reasonable location immediately. Just got to have somewhere to let her go. Let me see if Mr. Mitchell, anything from your perspective?
No, Your Honor, we're in agreement that she needs a better placement once some placement has been found.
So, Dr. Hudson, she hasn't been determined to be incompetent. Let me put it that way. I'm not saying she's competent. I'm just saying she hasn't been determined to be incompetent. So if she either agrees to go somewhere voluntarily, live with a family member or a friend that's going to take care of her and it's a safe environment, or if there's another way, such as a guardianship or a valid power of attorney to get her somewhere, I would certainly consider that. I'll get Mr. Mitchell's input, Mr. McDaniel's input. But I can't just say, put her out of jail, send her out the front door.
Right.
Can't do that.
Yes.
In good conscience.
I understand. And it's probably safer to be there than to be out on the streets anyway.
So,
because there's not a family member that can control her, and to be there 24 hours a day.
Well, thank you for coming, Doc. And if you get any additional information, please pass it along to Mr. McDaniel, and then he'll pass it along to the rest of us.
And I do know the sheriff's office was trying, they said it may be a place in Ponce de Leon that she may be able to go. So I'm going to call her again today from the sheriff's office to see if.
Who is that contact person that you were talking to there?
Probably Investigator Willis Hodges.
Peggy Hodges.
Yeah, Investigator Hodges.
Yes.
Yeah, I know that she's been working on this case a lot. She called me. They made the first arrest with warrant questions, and I explained you don't have to have a warrant. At that time, it was spitting on an officer, I think is what he was accused of, and she was accused of spitting on an officer. So there was no warrant because it was a officer. The felony allegedly occurred in the officer's presence, but I don't think they were wanting to charge her. They were looking for other options. They just didn't have any.
Well, they didn't know, and they've been experiencing that as we have as well, because she does the same thing to us and throw things and different things like that. That's why we're trying to find a facility that can manage that.
Well, if there's a way to get her to a facility, I said her a low bond, but I would even consider something else to get her out if we get that option.
Okay.
Thank you for
I'll
coming.
work on that.
Thank you, sir.
And I
Thank
contacted
you, guys.
DCF, and they're not gonna do anything if she's in jail. I mean, they're not even gonna come interview or anything. So I still think that the solution is the sheriff's office has to wait till the DCF shows up,
So-
and, you know,
Mr.
they won't
McDaniel-
come out of here.
Mr. McDaniel, if I were to release her, I can't release her to DCF custody because they haven't accepted custody of her and there's no court order, right?
Correct. I mean, no, if there was no criminal charges and the sheriff's office had no place for her to go and she was you know, an elderly person like that, they would call and they would have to wait till DCF shows up.
I don't know you think, your impression is if you have an elderly person and the sheriff's department's involved, let's just take the criminal case out of this equation for a moment. There's an elderly person and there's no one to care for them, that DCF will accept responsibility and find a placement for them. That's your understanding of the law?
Correct. That's my understanding. I'll try to find, I don't know case law on it, but I mean, that's what they're there for, is to help, you know, minors and elderly and,
I don't know,
you know,
the
even on the
Department of
website,
Children
it
and
says-
Families, I don't know if they have the ability or the mandate to find placement for individuals. If that were true, we wouldn't have a homeless crisis. I just don't know that that's accurate, Mr. McDaniel.
Yes, sir.
I don't know. I've never seen it. I mean, we've got a lot of people that need placement.
Correct. It is, and it goes to where if they're in danger, now if they're not in danger and if they're not incompetent and they're, you know, that's what a lot of the ones that you see are homeless are like. Yeah, they're not in danger and they're not incompetent, but if someone that can't walk and is bedridden, that's, you know, in hospice care, you know, I mean, that's a little bit different. And, you know, I think that's a little bit different on that scenario. And I think that they would have to come in and try to find some place to, normally what they would do is try to talk to family members. And I'll be honest with you, they will twist arms, family members, to try to get them to take them. That's how they would handle most of those situations. But when everything else, they can't do anything, they would have to be responsible to find some place to take her, which may be a hospital, you know, and let her sit there at the hospital, you know, until they can find something.
And I think in this case, she was in the hospital and then she was released from the hospital and that's when all this happened, right?
Yes, sir.
Okay. Well, thank you. Thank you, Mr. McDaniel, for trying to find her a place, and Mr. Mitchell. And thank you, Dr. Hudson, for coming today.
Thank you.
Thank you, sir. All right. So, Mr. McDaniel, it's everything I had on my first appearance list this morning. Have I missed anything, sir?
No, Your Honor.
Corporal, what about from the jail? Anything from the jail?
Nothing from jail, sir.
And Mr. Mitchell from the state?
Nothing from the state, Your Honor.
Is Monday an arraignment day?
Yes, Your Honor.
So I'm trying to think ahead. We've got, we're going to have 4 days of possible first appearances that we need to see, the ones that, at least misdemeanors that we can make an offer in. How big's the docket for Monday? Well, it's not bad at all. So if it's only 25 cases, we should have time, Mr. McDaniel, to see everybody we need to see and make any offers we need to make and still do a full arraignment day or half a day, whatever it's set for. All right. Well, thank you. Hope you have a great weekend, a great holiday.
Crystal Vaughn, Bruce, there, Lou.
Vaughn, yeah, Crystal.
Okay, what are we gonna do? What are we gonna do?
Dr. Vaughn,
I know.
says that she's competent
She's
and
competent.
I have had all kinds of problems, but I talked to her this morning and she wants a hearing on this motion.
Okay, when can we be ready?
It's only about non-reporting, Judge, so.
Come on now.
They can actually do it now if they want to.
Judge, I would ask that I have serious concerns. Every time I've gone to the jail, there's one that they report to me.
Are you Crystal Vaughn?
Yes, sir.
Okay, you understand Mr. Smith is your attorney?
Yes, sir.
Okay. You also understand there's a motion to revoke unadjudicated probation that's pending? Yeah, I'm talking to you.
No, sir.
You were on, you
No.
don't remember being placed on probation?
Yes, sir, I do.
Okay, then back in July, the state filed this motion. Have you had a chance to review it?
No, sir, I have not.
As I went out for the first time, I went over with her this morning.
This morning?
In the room.
Oh, you don't remember doing that,
I wasn't in the jury room, sir, going over this.
ma'am?
I wasn't in the jury room going
Where
over
were you?
this. I was at the other unit, at the stalls unit, KA dorm.
You understand, but you understand there's a motion to revoke probation that's been filed against. You said you went over it.
No, sir, I did not go over it because I was not told that a logger was at, I guess, where were you? At the main part?
All
I
right.
was in
Let me
KA
help you.
dorm. I did not realize it.
That's what
I was there to tell
that's the fail right there.
I understand, but
It's not
look,
fair.
Dr. Rapon has analyzed her and deems her to be competent. And
The problem that I have with Dr. Pond's report is that he had previously examined her a year ago and reported that at that time she had been previously diagnosed with dissociative identity disorder. And she had also been diagnosed with personality disorder when he did his examination on November the 4th. With my client, she reported that she had no prior problems with any kind of mental health problems, which directly contradicts Dr. Papon's report. I have been out.
no, that doesn't contradict. It says, his report says she states.
I get
And then
that
you
she
know
thinks
that, well, that's not what he concluded. I mean, but he concluded that she was deemed competent. So that's what's accurate.
Yeah.
Okay.
But if we're going to have a hearing, then I'm going to want to subpoena some officers from the jail.
Okay. When can you do that?
Well, I'm fixed to have surgery, and as we well knows.
I don't really know much about, I know people, I had appendicitis once.
Yeah.
That's about it.
I'm having 12 inches of my colon.
How long is that going to take?
Well, I'm in pre-op all this week. The surgery is Monday.
And then what's?
They say I'll be out at least 3 weeks then.
We may purchase some work.
We, Crystal,
Yes, sir.
we might not be able to get to this for about a month. Is that okay with you? Or do you want to move this quicker?
And where would I stay in the meantime? I'm
You're
at
gonna head to
KA
the
dorm.
jail.
Huh?
In the jail.
At KA dorm, the where
Yeah,
previously.
so, yes, ma'am.
Yes, that's fine, sir. I would like to say
Okay.
though in my defense that I did report this to Mr. Anton at Bridge City, Police Department, where my car was vandalized and I was unable to report to parole. So I reported vandalism of my vehicle to Mr.
Okay.
Anton.
It's not parole, it was the probation officer.
Well, the probation officer, sir, but I was unable to make it. I couldn't walk from Bridge City to Beaumont or wherever it was since I've never been in trouble before.
Oh.
But I did report it. I also reported a break into my house at the same time where the keys were stolen from my Audi at the same time. It was reported to Mr. Anton. He actually wrote it in a little notebook, refused to do a report. However, after that, the people at the water department, you could actually call them as a witness. They knew. I actually approached them first about it. So there were witnesses, sir.
Judge, I just want you to note that the accusation.
Time she report, when was she?
She's never reported is reason what I was trying to bring to your attention, Judge.
All right, everybody's talking at once.
What's about
She's placed in probation in May.
And you don't,
report it.
hold on. I had two people and now you piped in as a third.
Well, that's.
This is a chorus. It's not a chorus, it's, solos. All right,
Yes.
first of all, Bruce.
She was placed on probation in May this year.
Okay.
The allegation is that she never reported to the
When was
probation
she put
department.
in jail? When was she placed in jail? Does anybody know? Jeannie, do you know when she was?
She was released from custody on May 28th of 2025. And she was placed on probation, obviously the same day, but.
No, when did she end up going back to jail?
When on the warrant,
This is the fifth, I believe.
Mr. Renard made contact with her, in Jefferson County Jail on August the 15th of 2025.
Do you remember when you were arrested by any chance? Do you remember the day you were arrested on this?
I believe she was arrested.
After you were put on probation?
Your Honor, she was arrested August 12th.
Okay, hold on. So August 11th is what we're showing on the records. So she appears here on May 28th. She's placed on probation on May 28th. Then we've got June 28th, July 28th, 2 months and a couple of weeks.
Yeah, there.
Okay. And she was to appear how often?
Your Honor, she was to appear at the probation office immediately upon her release or the following business day.
The next day. And, okay, so according to this, the findings here on this administrative hearing, the defendant was released from jail on May 28th at 7:05 p.m., failed to report to the probation office the next day as required. That would have been May 29th, and has not made any contact with the office. So that's what prompted this is we go a little over 2 months and no reporting. I mean, when you're on probation, the first thing you have to do is report, and you just can't do it on your own,
My car broke down. An officer gave me a ride. From there, I reported.
No, wait, did you called? Who did you call with the probation? No, who did you
I
contact?
don't remember. It was on the paper. I don't have.
Do y'all have any?
No. I called.
I'm talking about.
No one answered. No one
Yeah,
answered. So I called and I went over to
What time were you
the
calling
water
during the
department.
business day?
No, it was later in the
At night, at
evening.
midnight?
Yeah, and then I called in
You
the
called at
morning, and then I
midnight?
went over to the water department because I was.
How about during the
and they-
day? Did you call during the business day?
Yes,
When?
I think it was.
Let me just tell you, I've never had a problem in
7:48.
20 years. I contact them, somebody always answers during the business day.
Okay.
So. Well,
It could have been a reroute on the phone. I don't know.
you think so?
Well, landline.
Yes. Well, generally that doesn't happen, and we've got to kind of figure out what's reasonable with this.
Well,
But in
reach the
probation,
officer.
you have an obligation that instead of going to prison, we gave you a chance to work through this during probation. And the foremost responsibility you have is to report. You have to do that. Everybody has to do that. If you don't, you're not on probation. It's just the way it is. It's simple. So you have an obligation, like all the probation officers have. You've got to figure it out. And the phones were, come on, we have to see you in person, and that's vital and necessary. But here you're flirting with 10 years in prison. Why would you do that?
For parole violation? Or
Evading arrest, or just you're on my probation for evading arrest, or do you not remember it? Good,
Evading
good.
arrest, but
We
I'll
went
send
over
it to you.
this. We went over this so delicately and deliberately. You're looking at 10 years in prison if you fail on this.
Okay.
One failure is something you could be revoked for. We hadn't seen you in months. You're supposed to be appearing regularly, or you're not on probation. That's the first thing. You got to show up. I don't know how you feel like you can't otherwise do that.
A vandalism to the car recorded.
You got to call. We have every business day they answer the phone. Come on. I've never had a problem in 20 years. You're not going to be any different. The very first thing here, you've got obligations, and you've got 35 conditions here. But the most important is to regularly report so that they're supervising you. If you can't do that, then you can't be supervised, which means thus you can't be on probation. And then there's only one other option, and it's up to 10 years in prison. Have you ever been to prison before?
No, sir.
Good. You don't want to be. You don't want to go. You don't want to.
No, I'd like to see my grandchildren. I really.
Well, they come in, they come in handy, as, wonderful parts of life. But this is a responsibility that you have that can get in the way of all of that. And I mean, if you do it here, you would be parolable until 2.5 years were served. That's a long time not to see the kids. Anyway, what's everybody want to do right now?
My argument is that I truly believe, with talking to everybody that I have talked to, talking to her this morning in there, I truly believe that my client has been ill. And this is.
Dr. Grapan decides otherwise, sorry. She can say whatever she wants out of her mouth until you can be the psychiatrist. All you can do is respond to what she's telling you, and the doctor knows better. And we're just going to, you've been doing this longer than I have, Bruce, and you know sometimes they're not forthright with you. Often your clients aren't. That's the way they were with me. Yeah, we all have, it's the way things are. The question is until Dr. Grapan deems otherwise, she is presumed competent.
You asked the question, what should we do? My answer is,
what do you want?
In my opinion, her failure to report is totally due to her mental problems, that I feel that she needs to be reinstated on probation and a mental health type of, so that she can receive the kind of help that she needs, because she is going to have that constant.
What's probation office?
Your Honor.
What did y'all think about it?
All I can base my, any statement on is what Mr. Menard had stated, when he made contact with her August 15th of 25 at the jail. And he also noted, a mental health, concern.
Well, what should we do?
Other than that, we have no information on her because of the fact she had failed to report. We don't know where she resides. It sounds like she resides in Orange County. We can submit.
Is that where you live?
Orange County.
Is that where you live now?
I live in, yes, I live in the historic district in Orange, in the city of Orange.
All right. Because if I release you on this probation,
yes,
you've got to follow. You know, we're making a big deal about this. This is important. The foremost thing you have to do is report. Foremost, it all flows from there. Failure is not an option for you. You go to prison. Do you understand? That's where you would head up to 10 years. And the court, you have to report. If you don't report, you're not in the game. And you got to be in the game. So that's the very first thing you have to do is report as directed by the probation office. We're going to also, when you're going to be released, I'm going to release you. And the first thing you do is you go to the probation office if it's during the work day. Do you understand that? It is the first work day you're able to report when you are released. You go to them. If you don't, I will order a warrant and I'll say, we talked about this and shame on you. You know what you have to do. You follow their directions as well. Do you understand? You have to speak out. Do you understand that?
Yes.
So that there's not any confusion.
Okay, I don't have a vehicle as of this time.
Mm-hmm.
It's still messed up. It's in the front.
Where do you live? In Orange, you said?
Yes, I live in Orange.
Okay, how do you
So
live?
it's in Brood City. I stay in Brood City some. It's across the street from the water department.
Does somebody have a vehicle that helps you move from one place to another? Do you have children or anything?
Yes, sir, but I
was
packing my bags.
Ma'am, but is not an option. You've got to report. How are you going to do that?
I don't know without a vehicle, sir. That's what
You will see a lot of people who don't have vehicles. They still are obligated to report. Yes, Jeannie?
Your Honor, and what the defendant is speaking of is if we tried to submit her case for courtesy supervision to Orange County, Orange County does not offer a mental health caseload. However, they do have spinal tap services available in Orange County. But if her inability to even advise the court of where she resides, she can't reside in Bridge City and Orange. She has to reside in one location. Orange County will not accept that without one location being reside. And now she's just speaking of going out of state. We don't just go out of state.
No, that was prior to. Prior to.
That's not what she just said, Your Honor.
I know.
I caught the same thing.
I know.
It's in,
The more you speak, the closer you get to prison. I've got to be able to trust you to release you. Can I? I'm asking you, can I trust you?
Yes, sir.
To follow the, all right. You're gonna have.
Yes, sir, but I don't have a
You're gonna-
vehicle, so from where I'm just being honest. So if you release me, do you release me from here? I don't know. I've never been in trouble before, so I don't know. So it's not being confrontational. I just.
Yeah. You're, we're trying to work with you here and you're kind of pushing back. You either are able to report or not. If you can't report, that's a problem. You have to be able to report, but you're on probation. You got to figure it out. Everybody does. We have 5,000 probationers.
Practice stuff. Yes.
the question I've got is what happened with that Orange County? If she's under their supervision from that offense, it might assist us in resolving.
Bruce, on your, well, what did you figure? What'd you figure out on that other case that was pending in Orange County? Do you know what happened on that? You're charged with evading arrest or detention with a vehicle out of Orange County. Do you know what happened on that case?
Detention of a vehicle.
Yes, I just spoke.
I'm not aware of Orange County having.
Evading arrest or detention with a motor vehicle.
Charged before and I was released and it was to probation. And failure to appear, I guess, for probation is a charge, correct?
No, I think he was phone calling to find out for that.
I think we
Here's what we're gonna
And,
do
um,
is we
I
figure this out. I'm gonna reset this for a week. Okay, I'm gonna reset this. And there's a lot of gaps that aren't being filled out.
As well.
Ms. Vaughn, you
Last time I checked,
try
it
to
has been died.
give us information that is helpful or not, but you're acting like you don't even know anything about yourself. And we'll figure it out.
I
But
do
it's
know
gonna take a
about-
while.
I read
And you
the
can't help
videos of
but,
the
you can't help but
vehicle.
interrupt people, can you? That's even rude. We learned that first. We're gonna see you back in 1 week. Thank you.